Please let us sit. Please let us sit close to each other to create space for others, please. I would like to make a plea to you to not use your cell phone for recording, please. It's distracting our recording machine, please. There is an echo behind microphones, please. Thank you.
Mr. Leach, I just want to ask a question about how absence of information fits into a public participation challenge. I accept that if Parliament has information relevant to a bill and doesn't share it, and that impairs the quality of public participation, that would be a defect in public participation. But that seems not to be quite what happened here. It wasn't that Parliament had information and didn't share it. The main criticism, and I may be putting it in slightly crude terms, was...
Am I the only one who's struggling to hear Justice Rogers? Okay, carry on.
To put it in crude terms, the complaint seems to be that Parliament didn't have the information and considered it wasn't necessary for purposes of passing the legislation. So, if one assumes the facts were as simple as this, that Parliament said, I hear you that you think we should have costing information and that we should have details about what's in the basket, and that this shouldn't be left to later development and regulation, but we don't think it appropriate to go that route. And therefore, we haven't yet got information about what will be in the basket. We don't know what will be in the basket, and we don't have information about cost. That will depend on future events. Now, if that's Parliament's attitude, and members of the public know that that is Parliament's attitude, they want to pass legislation in the absence of that information. They don't think it's necessary. Now, the public can engage on whether Parliament should go ahead and pass legislation in the absence of that information. But they have what they know in order to participate on that question. They know that Parliament thinks it is unnecessary to have detail about the basket and costing in order to pass this legislation. So the legislation, by definition, will be going ahead without that on Parliament's provisional view. The public can have input as to whether that's prudent. But if Parliament goes ahead and says, well, we still think it's appropriate to go ahead without that information, is it truly a case that information relevant to public participation hasn't occurred? Or is it merely at that point a substantive irrationality challenge that Parliament couldn't have passed the law rationally without that information? And this case may be important in establishing what we mean by making information available. It doesn't necessarily mean forcing Parliament to come up with information that it believes is unnecessary for purposes of passing the law. And it's that question as to whether that information is or isn't necessary rationally to pass the law that can be the subject of public participation. And obviously, if the public participation succeeds and Parliament is persuaded it does need this information, well, then maybe it will do its best to compile it. But if Parliament isn't persuaded, why is it a public participation defect that it then chooses to pass the law without the information? I can understand why it might be a substantive rationality criticism, but why is it a public participation issue?
I've been asked to switch off and switch on, so if it annoys anybody, I apologize. Justice Rogers, there are a series of answers to the proposition that I would like to submit to the court. The first is this: the in principle question that lies behind the proposition is one that, with respect, has already been answered by this court, starting with doctors. Because when the court assesses the reasonableness of the public participation process, it will look, I beg your pardon, at what Parliament did. And if one of the requirements of the public participation obligations is the provision of information, and this court says that that information was reasonably necessary for the public to make a meaningful input, then the fact that Parliament didn't have it or willfully shut its eyes to obtaining it is no answer to the question, the in-principle question, because that in-principle question has already been answered in the reasoning and the ratio of not only doctors, but the cases that follow it. And
remind me, in Doctors for Life, what was the nature of the information that wasn't provided and that this court said should be provided?
Doctors for Life, I'm talking there specifically about the principles. Can I come to Corruption Watch? Because Corruption Watch, it was the question of the CVs that should or shouldn't have been provided, that weren't provided. But there's an important passage in Corruption Watch. It's at paragraph 36, and it's a passage that perhaps also answers a proposition that was put to me by Justices Cheeky and Colopin earlier. There the court said this court's judgments, and it's referring to, amongst others, doctors and the cases that follow doctors, this court's judgments serve as a guide to the elements of an effective and meaningful public involvement process. The public and organs of civil society must be informed of the matter requiring public involvement. This is an elementary notice requirement. Sufficient time must be given to allow for public participation. And if I can pause there, because the court has no difficulty assessing whether or not the time was reasonably sufficient. The court exercises that supervisory role. Doesn't leave it just to Parliament to decide. Participation must occur at a stage in the process when it is possible for public participation input to alter or influence the outcome of the parliamentary process. So the court would again look at what the outcome is and what information was reasonably required at the time to influence the outcome of the legislative process. So my submission to the court is that the principles that lie pregnant within the proposition that's just been put to me are principles that have already been decided not only explicitly but in the underlying reasoning and ratio of the cases starting with doctors. But there's a second aspect, which is this. If Parliament, within their meaningful engagement with the public, applies its mind and says to the public, we have as Parliament elected not to seek this information. We are therefore not going to give it to you. That would be part of the dialogue and collaboration, the engagement with the public that takes place. But that never happened here. The public kept clamoring. They kept asking for the information. And the BHF is at pains to point out that it wasn't that Parliament came back to them and said to them, this is our answer. The BHF is at pains to point out that they were simply ignored. There was never an answer given to them. There wasn't even an answer that said, we've considered it and we're not with you on this, we're going to find against you. And it comes to a question that was put to me earlier, I think it might have been by Justice Colopin. And now the thought has escaped me, I apologize. Bear with me a moment, Chief Justice. I'm sorry, the submission is gone and it won't come back. I poor-locked myself. But the final answer to the proposition that's been put to me is this. If that was the engagement that came back from Parliament, that we've considered it and we've dealt with it and this is what we're going to do, then that may well fuel a substantial rationality challenge. But that option isn't open here, partly because it's never been disclosed from Parliament that that's its position, but secondly because that's never been the case that has been made out. The case has never been from Parliament's side that we couldn't get the information or that the information wasn't available to us or that this information wasn't reasonably necessary to you for meaningful public participation. They've taken the case down a different route.
I understood, now whether it's something that has emerged in the litigation or whether it was plainly articulated in the public participation process, I'm not quite sure. I understood Parliament to take the view that there's no point in trying to do this because it will be too speculative an exercise for something that is going to be implemented over 20 years or more. Any cost estimate is going to be wildly, or it's going to be irrelevant. The rabbit hole that one of the, I think it was a Dr. Crisp mentioned. I can understand and take the point that if Parliament simply never explained why it wasn't providing this information, if it was never conveyed to the public that the information was considered to be irrelevant and not obtainable at the present time. If the reason wasn't articulated, that could be an absence of public participation. But just to go back to the point that I started with, which was assuming that reason had been articulated, and Parliament had received representations from people who thought getting this information and being more definite now was important, and Parliament said, we don't think so. Then it seems to me anything that happens after that is a substantive rationality challenge to the legislation. The public know that the information hasn't been provided, they've asked for it, and Parliament has said, we don't consider it relevant at this stage, and we don't have it. Because otherwise one's really, through public participation, if this court found for your client specifically on the failure to provide information, we'd effectively be saying to Parliament, you can and must provide this information, where Parliament may say, we don't know. We don't know what's going to be in the basket when it's first implemented. So we can't, and we don't know exactly when it's going to be implemented, and therefore we cannot talk about costs. I mean, why can't Parliament say, I've heard you, but now not the court, I've heard the public, and we don't think that we need to have the information at this stage. You may complain that they're leaving too much to regulation, and sometimes legislation is attacked on the footing that too much power is reposed in the executive. That's a substantive attack. But why is it a public participation issue? I mean, if a budget had been given, it's going to cost R1 trillion over 5 years or whatever the number is, I don't know. Then you might have engaged and say, well, it's going to be big or whatever, how are we going to fund it? But if Parliament says, we don't know and we're not going to bother to find out because we don't think it's relevant. You know what Parliament knows, and you can make submissions on it as to whether they should find out. But why can't Parliament reject that and pass the act and leave it to you to say they behaved irrationally? And I take on board what was your second answer to my question. That's different. If Parliament hasn't engaged at all and hasn't articulated its stance, that could well be a failure of public participation.
Bear with me a moment, Chief Justice, if you would.
I can just mention, in the case of Corruption Watch, as I recall, the CVs were available. They weren't shared for one or other reason.
Sorry, I was just looking for a note. Sorry.
I was just going to say, if you couldn't find it, you could hand that one to Mr. Sorry, yes, for the reply as well.
He's feeding me stuff already, Justice Rogers. I'd like, if I may, a moment just to develop the argument a little, because the argument, of course, has its roots in Section 59 and Section 72 of the Constitution. And those sections are not passive sections. Those sections are mandatory, and they impose a positive obligation on Parliament. That positive obligation is more than just telling people that they're going to be passing legislation. And the cases that have picked up on that have emphasized that positive obligation, including the triumvirate of cases that dealt with the amendment to the Constitution, which required Parliament to go further than simply give notice and invite submissions, but went so far as to stipulate that there should, in appropriate circumstances, be education as an antecedent to allowing people to make their submissions. And that comes to a proposition that was put to me earlier, which is the question of positive steps and positive requirements that must be placed on Parliament. That requirement for taking steps is one that is not only present in Corruption Watch and the triumvirate of cases, but also in the Lamosa decision as well. So where underlying Justice Rogers' question to me is the implicit proposition of can this court oblige Parliament to give information? This court doesn't oblige Parliament to give information. The Constitution obliges Parliament to ensure public involvement in the legislative and other process. And in the same way that this court will exercise a supervisory role in relation to time, education, resources, transport to and from hearings, with respect, don't see a difference in principle between requiring Parliament to give sufficient information to mean that the public is able to engage meaningfully. But if the court says that Parliament is at liberty to decide, to use the example that has been put to me, to decide that we're going to shut our eyes, for whatever reason, we're going to shut our eyes to the required information, and we're going to pass the legislation blankly, then if this court says that that's not something that it can engage with on public participation level, but must only deal with at the level of a substantial rationality, then the court is placing a premium upon Parliament's performing its job poorly. The court is saying to Parliament that as the worse you do it, so the correspondingly there is a reduction in your public participation obligations. And I can't, with respect, believe that that would be a message that this court would want to send to Parliament. But I remembered what the proposition was that Justice Colopin put to me. When Justice Colopin, with respect, very eloquently and succinctly summarized the core issue at the heart of the case, and I agreed and I said that that is the core issue. The core issue is one about provision of information, but it goes further to this question about meaningful engagement. That is a case that is made out on the papers. It's not a case that is simply one of the absence of information. It's a case that goes further. It's a case, and in our heads we dealt with that as well, about the absence of meaningful engagement. So I hope that's answered the question that was put to me, Justice Rogers, and I don't expect an answer as to whether it has, but with respect, we don't share a concern about this court's oversight role in relation to Parliament that lies within the question that has been put.
Mr. Litch, I'm this side.
Yes, sir.
I have four issues that I want to raise with you in an effort to test whether your proposition is correct or not. One relates to sufficient information. Second one relates to reasonableness. The third one relates to unanimity or consensus. And the fourth one would be, or would relate to, whether Parliament is obliged to adopt or reject the views. And the last one would be, what is this benchmark for meaningful consultation, which you contend that Parliament failed on it? Well, let's start with the sufficient information aspect. Can we say on the facts of this case that sufficient information was not given to the members of the public as to what the NHI is? And when members of the public were engaging with the officials who were explaining in detail or whatever what this bill is intended to achieve, can we say when the members of the public left those gatherings, they left in a position not knowing, not understanding what this was all about? That's the first point. Once you proceed, we'll go to the second one.
Thank you, Justice Matopo. Justice Matopo, the question of whether sufficient information was provided, as I understood its formulation, referenced the quality of the information that was provided. The point that the BHF makes is that after the commencement of the public consultation process in the National Assembly, there was never information provided. The BHF takes it one step further, and it says...
Sorry, let me not interrupt you, but if you allow me to. In my question, put into the mix the role of BHF as a member of the public as well, because it represents a group of persons and entities who constitute members of the public. And then, once you've done that, we would have to weigh in the interests of the members that BHF represents and the citizenry to see where lies the problem that there was insufficient information. Is it insufficient information vis-a-vis BHF or the public in general?
Justice Matopo, the answer to the question is, and I'm using the BHF as shorthand, the answer to the question is that it was insufficient information. It was no information provided to the public in general.
Sorry, no information. If you're talking about the three aspects that you were referring to, is that where we should be confining our debate to? Or generally you say, with the whole process, there was no information that was provided to the public, or lack of information that was provided, or, as my brother Roger said, absent of information. Let's just be clear what we're dealing with there.
Justice Matopo, can I say that the report, the Portfolio Committee report, to which I referred the court earlier, identifies at various places in that report the information that is called for by the public. That information included calls for information on the three issues which I've identified in my submission. I've only identified those three issues because time is limited. And equally, the BHF, in its founding affidavit, limited itself to certain themes because they said time and space was limited. But there were 13 or 14 themes on which information was sought. And those themes cut across the length and breadth of the bill. Some of those themes, like funding, were issues that, and the basket of services.
Can I just say this? As I understand, the gravamen of your complaint would be that you don't know what this animal is going to turn out to be. In other words, it's a basket that are said to have been or to be provided for. Then I would ask the question, if that were to be the case, what is it that was put before the public? What was the public told when those two costs or issues are raised? Was the public told about the cost? And if so, what was the public response? Two, what were the basket of services that were said to be missing or to be provided? And if the public, notwithstanding those two or three that you've alluded to, the public said, we are still satisfied that this bill can pass through. And just imagine a scenario, if Parliament had said, when costs were asked to say, we project this require or 3 billion or 4 trillion, and we prepared to make provision for that. But you would come back and say, but we don't know how this is made up. Parliament will never ever kickstart this process if that were to be the position. Am I correct, or am I just missing the point?
No, with respect, Justice Cheeky,
No,
I'm sorry, I apologize to both justices.
no, really.
With respect, Justice Matopo, it's not a situation where Parliament would never get out of the starting gates. The question was not one of being obstructive towards the bill. And I know I keep coming back to that the Green Paper and the White Paper, which were both before Parliament, both contemplated that work would have to be done in order to work out, amongst other things, costing and the basket of services before the bill progressed. And the BHF wasn't opposed to that. The BHF said, we will help you work out costing and we will help you work out basket of services. And that is not an attitude that is opposed to access to health care for the marginalized or the poor. That is an attitude that is in fact in favor of the rest of the community. So the BHF wasn't, despite what the Minister said in his affidavit, representing a narrow interest. The BHF was representing a considered interest on behalf of the public. But it wasn't only the BHF. There were 7,000 odd submissions that were made calling for the same information around funding. And that was never provided. There were 7,000 submissions calling for information on other issues, and that information was never provided. And the BHF is not, when I say to the court that the BHF says that it never got information, what I'm really saying to the court in my tired, lackadaisical way at the moment is no one was given information. From the date that the public participation process commences until now, there has been no information given in response to requests for information from the department, from the public, as part of the public participation.
I would have understood your case much clearer. Perhaps it talks to the drafting. If, for example, it could have been set out more clearly to say, these are the defects that we are complaining about, and they are listed in your founding affidavit to say, because of this was not done, this was requested, request was rebuffed, and this was not done. And one would look at that and do an objective analysis and say, does this constitute sufficient information to the public? Maybe you've got 3 juniors there. Maybe in the fullness of time, if they were to do that, that for my purposes, that would certainly go a long way in understanding the cornerstone of your case, if that could be provided.
Justice Matopo, I think
Subject, obviously, to the consent of the Chief Justice.
your words carry more authority with my 3 colleagues than mine do, so I'm sure that they have heard you and have taken note.
Well, let's then move on to reasonableness. Are we home or not to say, when you look at the facilitation of public participation, it was one that was not reasonable, and given the objective facts, and if so, by virtue of what facts or facts is that submission made?
The short answer with respect is it wasn't a reasonable process, and the facts that bear that out are, and I'm not sure if I'm misunderstanding.
Well,
the
I said
question,
by virtue of what fact or facts,
but it was the short shrift that the BHF puts up evidence to show that it was given short shrift at the hearings. It was the absence of information. It was the absence of any real engagement. It was the absence of a response, both at the public hearings and thereafter. The BHF puts up in its founding affidavit the responses that were the engagements that took place at the hearings, and there were no engagements that took place at the hearings. That's dealt with in a table, I think it's BHF 16. So it's a combination of all of those factors that show that there was no meaningful engagement, public engagement. The Parliament didn't reasonably meet its obligation.
okay, let's consider the Parliament's prerogative, if I were to use that word. Parliament can accept the submissions, can reject the submissions. Parliament, in its own wisdom, will have to do the exercise. Not everything that is put before Parliament will invariably carry the day. And if Parliament said, we considered the submissions that were put forward before us, this is our position, what is the fault of Parliament there?
Justice Matopo, there's a big if in that question, which is that if Parliament said, we consider these submissions, and that's one of the points that I started with, is that there is no evidence of where Parliament considered these submissions. There's evidence of the department having considered the submissions, and of Parliament debating the department's response, but there's no evidence of the Parliament considering the submissions. There's no debate, for example, around the Portfolio Committee report. And I want to be...
I just want to understand this, because if I lose you there, I might misconstrue the contemplated argument from your colleagues on the other side. If the submission is that there is no evidence that Parliament considered the submissions, but Parliament, in other words, received or accepted the submissions from the department, is that what you say happened?
Particularly in the National Council of Provinces, Justice Matopo, and it's not only us. There were members of Parliament who said this public participation process is not meaningful. It's been a charade. because particularly in the National Council of Provinces, there's no evidence of Parliament engaging with the submission.
Parliament would be what? Engaging in this bill.
Either the Portfolio Committee, which makes a recommendation to the members of Parliament,
Yes.
or the parliamentarians, the members of Parliament themselves debating the issue.
So the argument that you are advancing is that neither the Portfolio Committee of Parliament or the other chamber of Parliament, which I don't know what it is, maybe the National Assembly, did not even consider this bill. I just want to be very clear, because this is a very, very serious submission to make.
Justice Matopo, the case was made out in the founding affidavit that there was no evidence of Parliament, whether in the form of the Parliamentary Portfolio Committee or the National Assembly, or of the National Council of Provinces, including the Select Committee. There was no evidence of that body of Parliament and its various constituent forms engaging with the issues. And it went further.
No, but then that would mean the documents, the views, the submissions were received, and if there was no engagement, what would Parliament have done there and there when they received the documents? Where would they have put them? Were they not spoken to?
Well, they were spoken to.
At what stage?
They were spoken to by the department. And that's where the department and Parliament start to part ways, because Parliament says that the department did all this, and the department says, but we weren't. We're a separate organ of state.
You will appreciate that this is an astounding proposition that you make. It surprises me that the department would deliberate and Parliament, and together with its own sister committees, would do nothing. And if that were the case, and I would have expected, unless if I've missed it, where BHF and others would have said, the case squarely before us is that there was no deliberation, no consideration of the public participation by Parliament, because everything started or ended with the department. It's that a case that has been made.
Justice Matopo, Parliament, I beg your pardon, the founding affidavit deals with a number of concerns.
I read it. I did not see this. And I must confess, if I missed it, I did.
One of the concerns is the absence of information that had facilitated public participation. The other concern that was identified was the absence of any meaningful engagement with those issues. The third was the absence of any evidence, particularly evidence emerging from the prior request, to show that Parliament had understood and debated and engaged with the issues that were raised by the public. They might not be in black and white jumping out, but those were certainly the issues that were raised, and they were the issues that were understood by the respondents.
To test whether, or to test or ascertain whether Parliament did or did not engage with that, your Hansard would give us a clue, isn't it?
Yes.
But what does the Hansard say?
Well, that's the difficulty, is that the BHF's attorneys have analysed those debates, and they come before the court and they say, we don't see it.
Seeing it means we don't appreciate it, because seeing is something else.
Meaning it's not there.
Not there.
And when that case is made out, it's not there. Then one would have expected Parliament to come back and say, don't be silly. If you look at page X at line Y of Hansard on this day, you will see it being debated. We don't see that in their response. We see them put up an annexure and say, there was a debate on this day and there was a debate on that day. But when you analyze those annexures and when you analyze what they say, what is missing in those reports and meetings and documents is that debate within Parliament itself. There's lots of debate that takes place between Parliament and the department, but not debate within Parliament itself.
I hear what you say, but it surprises me that such a proposition is made and that Parliament would sit idly and not respond to an allegation that we've gone through the Hansard. We have seen through the Hansard that there is nothing relating to any or closer to any debate about this. And that would be a scary proposition, and that would be a scary decision to be taken by Parliament, because if that were to be the case, it talks to meaningful engagement. Then it would mean that having submitted everything, there could have been a serious lack of meaningful engagement.
Justice Matopo, can I come back to one of my documents that I've referred the court to on a number of occasions, which is the Portfolio Committee on Health's thematic report. It's a document that, as I've indicated, dates sometime in 2023, notwithstanding the date on the front cover. What we would have expected is we would have expected that report to be tabled and for there to be a debate within Parliament or within the Portfolio Committee.
So who would have provided that document?
This was provided by the Portfolio
Committee.
So this is Parliament's own document.
Okay.
It's Parliament's own document identifying difficulties and problems that were raised by members of the public in the course of the consultation process. And what we would have expected is we would have expected somebody, somewhere, to produce something that shows Parliament, either in its full glory or a subcommittee or select committee, working through that document and identifying the themes and understanding what Parliament's position is in relation to those themes. But there isn't. There is no answer that we can find to AA7.
Thank you, Mr. Ditch.
Thank you, Justice Matopo.
Mr. Leach,
I'm
on the
sorry,
extreme side,
Justice Nnuku.
you said that at the core of PHF's case is the lack of information. And I must accept that lack of information is capable of undermining the meaningful public participation process. But would you also accept the proposition that the information required is the one that is relevant to the subject matter that the Parliament must deal with? If we go to the Corruption Watch case, for example, that committee was to appoint members, and surely the CVs of those candidates was relevant. So would you be able to accept that proposition?
Justice Nnuku, I accept. I think the cases make it clear that the information that is sought or the information that must be provided is information that has a bearing on the purpose and the outcome of the legislation that is proposed or the action that is proposed in the case of Corruption Watch.
Now, if you look at the NHI Act, my impression of it is that it was dealt with on the basis that it sets out the general framework. There are some details that will be worked out at a later stage, which would include such things as the basket of services, for example. So the Parliament has not spoken on the basket of services. Would you accept that?
Justice Nuku, I accept that at the time that the legislation was enacted, Parliament had not, the bill was passed, Parliament had not spoken on the basket of services, but Parliament had also deferred that to somebody else. That was one of the objections that was raised, was that Parliament was handing that responsibility on to unelected officials.
But maybe
appointed by the
we'll
minister.
get to that. So if you accept, for starters, that if the Parliament does not pronounce itself on the basket of services, the information relating to basket of services would not necessarily undermine meaningful public participation when the Parliament does not deal with that aspect.
Well, with respect, Justice Nuku, and it comes back to something that Justice Colopin put to me earlier, we have to understand, as Justice Colopin pointed out to me, we have to understand the public participation obligation, not in isolation, but also with reference to Parliament's other obligations, including the obligation in Section 27. And Justice Colopin, with respect, correctly said that you understand the two together, you read them together. But Section 27 has an important caveat. It says, Parliament shall, within available resources, progressively advance access to healthcare. You cannot divorce from the question of their obligations in relation to both the basket of services and the cost. You cannot divorce those two. You cannot divorce those two issues because they are integral to Section 27. And they are also integral to the negative obligation that rests in Section 27 that says government cannot take regressive measures or measures that will operate regressively. And that the public comments were around not only the absence of information as to what would be provided, but the absence of information as to the knock-on effect of what this would have in terms of reducing what was presently available, in particular through provincial and local government.
My question is more of a general proposition that where the board has decided not to deal with that particular aspect at that particular point in time, the lack of information relating to that aspect which is not being dealt with cannot, in my view, undermine the meaningfulness of the participation. Would you quibble with that?
With respect,
without reference to, I heard your explanation. I think you're dealing with something that I really did not get to, but as a general proposition.
Justice Nuku, with respect, you used the word quibble. I go more than quibble with that proposition because it's something that suggests an absence of any meaningful public participation, because Parliament can then promulgate legislation that is skeletal and ask for, in a manner akin to a plebiscite, ask for approval from the public. Are you in favor or are you against it? And that can't be fulfilling meaningful public participation. And it's not, we've concentrated for purposes of this debate on cost and basket of services and how the system will work. But I would urge the court to look at the graphic that was put up at AA7, figure 3, because the themes cut across every aspect of the proposed legislation. And if Parliament takes a conscious decision that it's going to close its eyes to everything, then it must have the confidence to state that explicitly, so that when it states it explicitly and says we're not going to worry about any of these things, we're going to ignore all the public participation comments, we're going to put the framework in place and we're going to proceed blindly, then we know the basis on which we're dealing. There's a further aspect to this. The bill that Parliament adopted has a financing mechanism. And that financing mechanism says that Parliament must appropriate the required money for purposes of funding it. So we can't, again, isolate what Parliament is doing from what the bill itself says and what the purpose of the bill is.
That's the end of your torture, Mr. Mr. Leach. We wait with keen anticipation to hear what Mr. Bobomia says in reply to the issues that defer to him.
Beg one indulgence to give a reference, again in response to the question, particularly from Justice Collopin, about remedy and where we should go back to. And if I can just give two quick answers. The one answer is a citation reference. It's Herbert versus Sinclair, 2019, volume 6 of the South African Law Reports, page 231, a decision of this court. It's 2019, volume 6, page 231 of the South African Law Reports. And the passage is at paragraph 39. And that passage talks to the fact that when a party wants something other than the setting aside, then it's for that party to come and explain to the court what the alternative remedy should be. And there hasn't been something that says we should go back to either this place or this place or this place in relation to the BHF's challenge. The second proposition is this. There's nothing stopping Parliament itself, when it comes back to this, to say we don't need to repeat everything that happened up until whatever point they choose. And if they get it wrong, then they run a risk of another public participation challenge. But if they get it right, then they're home free. So Parliament, whether this court does or doesn't set aside in blank terms, it's still open to Parliament to salvage some of the public participation process that has proceeded to date.
Sorry, there's just a question I need to put to you, and I'm battling to get to my case lines reference. It's a bit slow, so on that issue at least I'd agree with you. In the written submissions on behalf of the third and fifth respondents, they make a reference to your replying affidavit at paragraph 73, and they reference it at case lines 018-28. I can't read that paragraph, but they appear to rely on that paragraph for a submission that Parliament not only deliberated on the submissions but also sought legal advice on the issues raised. That's sort of in response to the engagement you had with my colleague Justice Matopo. I would have asked this question in reply, but I thought it's fair to maybe ask, can you tell me what paragraph 73 says?
Off the top of my head, no, Justice Colopin, but Mr. Babamir, and I'm going to let the bus reverse over him now.
Okay, no, that's fine.
He will deal with that.
In that case, you should have actually taken 15 minutes and given him the other 15 minutes.
But can I just say this, that there were replying affidavits put up that dealt with some of that.
Okay. I think my colleague might have it, so I don't know. No. Okay, that's fine.
Madam,
Sorry, Mr. Leach.
Oh, I beg your pardon.
I have one question to put to you. It relates to Annexure AA7 and the submission been made that I just want you to confirm or compare this with what was said in Merafo, that the mere fact that Parliament failed to report, just read it, Colin, does not mean that they did not consider AA7. And what
I'm sorry, I didn't hear you.
I'm saying, you said there was AA7 and there was no comment to AA7 by Parliament, and you've gone through the whole exercise. There is no way that Parliament commented. Merafong says in paragraph 55 and 56, let me just read my glasses. Yeah. And extrapolating the rationale there, it's the mere fact that Parliament did not report does not mean that Parliament did not consider it. And, okay.
Bear with me a moment, Justice Matopo.
Can I read maybe what Merafon says in paragraph 55?
I'm just pulling it up, so if
You can trust me, I'll read it correctly.
yes, absolutely. I was never in doubt about that.
It says in paragraph 55, from the perspective of respectful dialogue and the accountability of political representatives, it might well have been desirable to report to the people of Merafo that it was impossible to adhere to the position taken by the Portfolio Committee in the negotiating mandate. To the extent that the community was given the impression that the community agreed with them and that an understandable expectation was created that their views would prevail, it was possibly disrespectful not to return to inform them of subsequent events. The question, though, is whether the omission to consult again after the alteration of the Portfolio Committee negotiating mandate amounts to a failure to facilitate public involvement in the process of the Gauteng provincial legislation. Paragraph 56 says, in my view, the failure to report back to the Merafong community does not rise to the level of unreasonableness, which would result in the invalidity of the 12th Amendment, which was otherwise probably passed by Parliament. It cannot result in the finding that the Gauteng failed to take reasonable measures to facilitate public involvement as required by Section 72(1)(a) and Section 18 of the Constitution.
Justice Matopo,
You've seen it.
I've seen it.
And the response?
There is, of course, a difference between this and South African veterinary, where the court found that...
South African?
South African veterinary, so,
Okay.
where the court found that the amendment did trigger a further consultation process. But we're in a distinguishable situation here, because here in Merafong, there was engagement with the community, and the very point that Merafong makes is that there was feedback given to the community And Justice van der Westhuizen asks the question whether, once that feedback was given to the community, if there was a changed stance, did the legislature have to go back again to the community? The very point in this case is that there was no feedback given to the community. There was no feedback given by Parliament either at the National Council of Provinces level or the National Assembly level to members of the public, and in particular there was no engagement with the members of the public on the issues, the very clear issues that had been raised by the members of the public and in respect of which they were seeking feedback.
Thank you.
Thank you. Chief Justice, members of the court, and
There is one more question for you from the DCJ. Here.
I beg your pardon, Deputy
Mr.
Chief
Leach.
Justice.
The result I wasn't going to ask because I was covered largely, but in your debate, I think with Justice Matopo, regarding the reasonableness of the process, I think it was Justice Matopo, if not Justice Rogers, you said the process was not reasonable, and you substantiated that by saying because there was no response to what BHF submitted. Did I understand you correctly?
Deputy Chief Justice, I clarified later
Yes.
that it wasn't just the BHF. There was no engagement, there was no dialogue, there was no collaboration
Yes.
at all with any members of the public.
Yes.
That's the case that
But-
was made out.
Did I understand you to be saying you would have expected Parliament to come back and say, we've heard you on these points, our response is the following?
No, I'm not suggesting that there needed to be a tick box exercise of question and answer.
Yeah.
But where the public is articulating consistently across hundreds of hearings and thousands and hundreds of thousands of submissions, particular concerns,
Yes.
the question is whether or not ignoring those concerns across hundreds of thousands of submissions, whether ignoring them is reasonable in the circumstances.
Yes.
And our submission is that it would never be reasonable in the circumstances to simply ignore what had happened, particularly when those submissions are not just submissions of comment, but are submissions of comment and question. We would like to help you, but we would like more information in order
Yeah,
for us to
let me
be able
stop
to
you
do
there.
so.
So you're basically saying there should have been some response.
Well,
That indicates they've engaged with the issues. That's what you say.
the starting point is that there had to be some engagement with the issues.
Yeah.
And that engagement with the issues then at some point needs to be made known.
Yeah. I'll tell you why I'm asking you this. This court in Mohale was specific that Parliament is not compelled to respond, no matter how compelling the demand is. How do you relate that statement of this court to what you're submitting?
Deputy Chief Justice, I understood Mohale to be, in the particular context of that case, that there was no compulsion on Parliament to respond. But in the context of this case,
Yes.
the question is not whether or not Parliament responded at the end of the process. The question is one of the engagement that takes place. When BHF 16, I think it's BHF 16, when that is put up, it's put up with a very specific purpose, which says, we went there and we were simply ignored. There was no meaningful engagement with us. None of it. It's BHF 27, Mr. Darfel, I'm indebted. There was no meaningful engagement.
So you're saying that statement in Mohale is context specific?
It's context specific in our
That's your
submission.
response?
Or rather, it's not applicable within the particular facts that are being put up in this case.
Well, I understood it to be a general proposition, a general statement. But anyway, you've answered it. Thank you, Chief Justice.
Thank you, Madam Chief Justice.
Your turn, Mr. Manager.
Thank you, Chief Justice and Justices of the Court. I propose to address 5 topics. The first is just to give a brief comment on the context of the BHF's challenge, then deal with the issue of jurisdiction, and then make brief comments on the overall test that the court applies in assessing whether the obligation to facilitate public participation has been met. And then I'll address, as we understood from the heads of argument, the 3 themes that BHF pursues in order to demonstrate that there was a failure of public participation. The first is what occupied much of the debate today, which is the absence of information on costing and funding of the NHI. And second, that there are no defined basket of benefits in the NHI bill itself, in other words, in the Act now. And then there was a third complaint about the vagueness of the operating NHI model that wasn't really pursued this morning. And then I'll I'll conclude and deal with costs. Turning to the context of the BHI challenge, it approaches the court to challenge the public participation process, which the NA has followed, and to a lesser extent in its founding papers, the process in the NCOP. It contends that Parliament's public participation process was flawed, and it makes these allegations despite the following common cause facts. Both the NA and the NCOP invited and received written comments on the NHI bill from the public at large. In the NA process alone, more than 330,000 comments were received, and in the NCO process, some 23,465 comments, and these are just written comments. And all of the comments were considered and informed the legislation that Parliament ultimately adopted. Just on the AA7, which our learned friend dealt with, that annexure, in the concluding paragraph 6 of that document, the Portfolio Committee makes clear that there will be follow-up meetings to consider the consents which are summarized in that document. So there is no ignoring of submissions. They're taken on board for further consideration in subsequent meetings of the Portfolio Committee. That document is a 2021 document, and there are a number of meetings in 2022 where the Portfolio Committee considers, with the assistance of the department, the comments received. And both the NA and the NCOP, and this is admitted by BHF, conducted extensive in-person hearings in each of the 9 provinces. In the NA process alone, which is the focus of the BHF's challenge, the hearings were attended by more than 11,000 members of the public, and all of the hearings were streamed so that South Africans in every part of the country could understand the issues arising from the bill and the concerns expressed by members of the public. The NA took special steps to ensure that stakeholders like BHF could influence the legislative process. And you will see that in some of those meetings, they engaged the BHF on what its suggestions were, on what it says it was offering to do to assist the legislative process. It devoted 29 days in the legislative calendar to hear from stakeholders directly, and more than 100 stakeholders attended these meetings, including BHF. When it comes to stakeholders and the question of context and sufficiency of information, it's particularly important that the complainant is one of those stakeholders, well-heeled, that can, with minimum information, engage the services of experts to update financial information, the minimal that is available, to make projections on what the costs and funding requirements will be, and enable BHF to make submissions. BHF's contention that the public participation process was flawed is belied by its own acknowledgement, we submit, that Parliament's public participation process was extensive and intensive. That's lifted from its founding affidavits. We submit that the challenge is really not whether members of the public were heard, because they evidently were, and it is not about whether the views of the public influenced the legislative process. They evidently did. Indeed, the overwhelming sentiment throughout the public participation process was support for the NHI bill. The legislatures gave effect to the sentiments of the public expressed during the extensive public participation process. So the representative, both the representative and participatory part of democracy, where we submit were fulfilled. BHF's challenge is fundamentally about the outcome that the legislative process produced. And no public participation would have satisfied it. If, for example, it says, and this is a difference of approach, it says in order for it to make meaningful public participation on costing, it needed to understand the total costs, the full costs of the implementation of the NHI. Now, both the experts, the WHO that the department and Parliament relied on, which is quoted by Dr. Armstrong, which is the expert for BHF, both acknowledge that when you're using projections of costing going into the future where you have a 25-year project, those projections become unreliable. Both of them acknowledge that. In fact, the WHO says you will be going down a rabbit hole. It's unhelpful to try to cost a project of that duration. So what they're really complaining about is they don't like the outcome. And it goes to what Justice Rogers asked. If the information should have been before Parliament in order for the outcome to be rational, and that wasn't the case because the information on their submission wasn't available, isn't that a substantive challenge? That is exactly what we submit under the question of jurisdiction, which I attend to. But the real point in Merafong at paragraphs 50 to 53, that what public participation requires is not that one's views should prevail, but it is that the legislature is informed of the public's views on the main issues that are addressed in the bill, and they were likewise informed here. On the question of jurisdiction, what our learned friends have tried to do, both in reply and in oral argument, is to try to say that they brought two cases before this court. There was a primary case, which is the public participation case, and there is the secondary case, which is the rationality case. And they say that their case is similar to Mohale, is similar to Lamosa. But in those cases, the applicants demarcated two cases. They said we're bringing a public participation challenge under exclusive jurisdiction, and through direct access, we're challenging the rationality of the outcome. What BHF has brought before this court is an omnibus case. It has not demarcated between a public participation challenge and a rationality challenge. And in the first instance, from the judgment of this court in Zuma, it's important for them to plead properly the basis for the court's exclusive jurisdiction. That the court will find in one paragraph 8 in the founding affidavit, which simply asserts that this court has exclusive jurisdiction under section 167(4)(e) because BHF applies for an order declaring that the NHI was passed in a manner inconsistent with the Constitution and must be declared invalid. But when one then engages the actual case, you will see, in addition to those paragraphs 13 and 18, which our learned friends referred to in debate with the court, you will see that the substance of their challenge is that all of these complaints that they raise resulted in an irrational and unreasonable outcome. And they do so in a concluding paragraph at paragraph 212 to 214 of the BHF's founding affidavit. They say at 212, all these themes, financial capacity, superficial consultation, legislative vagueness, potential constitutional infractions, and overshadowing of procedural roles converge into a final critique. The adoption of the NHI bill by the NA was irrational. That is, the legislature pushed through a transformative measure without ensuring there was a rational relationship between the bill's laudable purpose and the actual mechanism put in place. And they then describe what rationality in their understanding entails, and that's the classic definition in paragraph 213. That's in relation to the NA, and they conclude the NA reached a result that is patently unsound. And then in respect of the NCOP, they concluded paragraph 221. The summary of the debate, aided by the analysis below, whatever they're going to say after 221, demonstrates how the majority of the NCOP disregarded fundamental concerns raised during the public participation process, rendering their decision to pass the bill irrational and constitutionally indefensible. So the challenge we submit, the substance of this challenge, the core of it, not the secondary part, the core of it is about the outcome. And there is no breach when the outcome is not what they sought or the outcome is irrational. They needed to apply for direct access for that, and they haven't. So we submit that we ask that the entire challenge be dismissed for not failing to bring a challenge that falls within the court's exclusive jurisdiction. But should we fail on that, and the court finds that there is a case, we submit to the court that that would be a narrow case, founded on this proposition that the absence of sufficient information rendered the entire process unreasonable, and in that, to assess it against the three complaints which are advanced, which is the costing and finding benefit, basket of benefits, and the vagueness of the legislation. And here we emphasize what the court already deals with every day, is that in assessing whether Parliament fulfilled its obligation, the court considers the cumulative consequence of the entire NA process or the NCOP process, not nitpicking different stages. It's looking holistically to determine whether in all of the circumstances a reasonable opportunity was afforded to members of the public and all interested parties to know about the issues in respect of the NHI bill and to have an adequate say in a manner capable of influencing the decision to be taken. And we submit that on all the facts and circumstances, that case has not been made out. And I turn to the first complaint about costs and funding. Now, our learned friend presented the case in a very general form that, in effect, saying the complaint is that between nothing and something in between should have been provided, as if that is really the complaint they've brought. But the complaint is not that. Their complaint is that Parliament breached Rule 2791C Roman 2 of the National Assembly rules by not presenting to Parliament with the proposal in the bill financial implications of the bill. They say that wasn't done. And then they say it also failed to provide sufficient information to the public for purposes of consultation. In relation to costing and funding, it's very clear what they say should have been done. They say Parliament should have conducted a feasibility exercise on NHI costing and funding to update the figures from the Green Paper and revised White Paper and provide a sum that represents the total cost of the implementation of NHI. That's what they were looking for. They want that number, to work with that number, and you'll see that that's what Dr. Armstrong does. She uses those old figures, updates them, to show you what the shortfall is per year of implementing NHI between what NHI requires and what the current spending by government on health is, and says for that you need 95% increase in taxes. So that's what she does. That's what they're looking for. They're looking for that number, and they say failing to conduct that feasibility study disabled the public to meaningfully engage in the public participation process. Now, the Corruption Watch says that what constitutes sufficient information depends on the subject matter on which public involvement is sought. In that case, you are recruiting people for a particular position, you want to know their suitability, but you don't have their CVs. It makes sense, and the CVs were in the possession of Parliament. They could have been provided. And it said there's no way that Parliament members could make proper contributions on the suitability without access to the to that minimum information. But the test is always one of reasonableness, and context still matters. And we submit that in this case, from the information provided, the public understood that this was a radical intervention which would have cost implications, and there would have to be additional funding. The issue is, did you give the number? And that is what they say is not sufficient information was not granted. Now, we start first with the implications of the bill in terms of Rule 279C Roman 2. You will find that given in the memorandum to the bill, which is part of Annexure BHF 14. And where the bill deals with the question of financial implications is at 003-843. And what it, and here it's what marks the difference in approach. What BHF wanted was, when you're dealing with financial implications, you must say it's going to cost a number to implement NHI. But the bill to Parliament followed the advice of the WHO, which said it is unhelpful to try to determine the total cost of the implementation of the intervention, because you would be involved in a lot of iterations when change to keep revising that number. It's unhelpful to get to that number, and they gave the example of Thailand. And instead, that advice was, because NHI is going to be introduced on a phased basis. So in the first year, for instance, you are concerned with improving facilities within the public sector. You can cost those steps year by year until you arrive at the position to implement NHI fully. And we know that that date is far in advance, it's decades away, and the minister has to declare under Section 33 of the NHI Act when that point has been reached, that NHI has been fully implemented, and medical schemes will then start playing the complementary role and not the role that they play currently. And what paragraph 8 does is to give you a breakdown of those costs which will be incurred in the step-by-step implementation in the implementation of the steps that ready you towards implementing full NHI. So first you improve quality of care improvement programs in 8.1a. Then you establish the fund. There is a cost to that. There is the actuarial costing model relating to a number of factors that must be taken into account. There is an HR capacitation grant. Sorry, up to 8.3, it's all costs that you are costing elements, and that's the advice of the World Health Organization that the department accepted, which Parliament was convinced and accepted, that is the better way to cost or to determine the financial implications. And then you will see from 8.1 to 8.3, you have the costing elements. Then 8.4 to 8.9 is the funding elements. So how are you going to fund all of this? 8.4, the rising fund budget baseline, it tells you how it rises from 2.5 to 3.1, and this is going to be provided for in the budget 2018 and 2019 spending of 1.7 billion. In the next phase, and in its executive authority will be able to bid for funds through the main budget as part of the budget process for the next steps. Thereafter, consideration will be given to shifting some of the conditional grants, such as National Tertiary Services Grant and the HIV, AIDS, and TB grants from the department to the fund, and you get a table of those different grants there. And then 8.8 tells you there's still a shifting of funds at a later point. And then 8.9, as you reach fuller and fuller implementation, you may need to raise taxes. But you can't tabulate the taxes yet in this memorandum, because taxing is it's determined in the budget process, and we know that taxation is a power that belongs to Parliament. So Treasury, the fund will say what it proposes must be funded by. That will be taken to via Treasury when it submits the Division of Revenue, and Parliament considers that and approves it, and then the funding is given. But you can't say today, standing here, we're going to raise this tax by this much, we're going to raise this surcharge, this payroll tax. You can only talk about the mechanism for funding yet. But they want you to say now, and Dr. Armstrong does the computation, But when you look at it, you will see that the way in which she computes the shortfall every year ignores the fact that this is a phased implementation. You don't start in the first year with full implementation and with a shortfall of requiring 95% of taxes. I'll give the references to Dr. Armstrong in a minute. So we submit with respect that the memorandum to the bill provided the financial implications of the bill to Parliament. BHF differs that that is the proper way, because in its conception, you should be telling Parliament that the full implementation of this project is going to cost X, and we're going to need so much money. Now speaking, we can't afford it. That's their point. But the Parliament took a different view, accepted the advice of the executive. There's nothing wrong in that. There is a basis for doing so, because the very WHO report, which is quoted, it's quoted in the revised white paper, which is BHF 11 at paragraphs 199 to 201, and the annexure number, the page number for the annexure B11 is 004 755 to 785. You'll find that annexure. And we quote from paragraph 199 to 201 of that report. It says, it is not useful to focus on getting the exact number indicating the estimated costs. This is because evidence has shown that countries that have gone through this route have ended up tied to an endless cycle of revisions and efforts to dream up new revenue sources, thus focusing on issues that have more to do with tax policy than health policy. Therefore, focusing on what will NHI cost, in other words, the full cost, is the wrong approach, as it is better to frame the question around the implications of different scenarios for the design and implementation of reforms to move towards NHI. What is it going to cost you, stage by stage, to get to full implementation? That's what you should cost. That's realistic, because the rest, it's unhelpful. Now, Dr. Armstrong, for her part, does not reject this WHO report. She references it in her report, and the court will find her report is BHF2. BHF2 starts off with the affidavit, her supporting affidavit, and then you get the actual report. And I refer the court in that, in her report to I might not have given the correct reference here. Let me quickly get it for the court. She referenced it at 003-350, and it's paragraph 221 to paragraph 226, where she gives proper treatment to that report. She acknowledges that the WHO says looking for the total number is unhelpful, but says it doesn't say you mustn't cost at all. But what she then goes on to do goes precisely against that advice. So she accepts it, but interprets it to mean that you can still try, as she does, to find the final number. The department read the same report, understood it to mean you fund your steps. Where is the unreasonableness in that? For the department to say, and then for Parliament to accept that that's the proper way to do it. On an expert report, which is of a world body that has experience from various countries that have implemented universal health coverage, and it's important to underscore that universal health coverage is not just universal health care, as in you can go to a public hospital and get any service you want. It is about funding. It is about funding so that everybody can access both the private and the public sector healthcare services, so that a person from a village can go to a Mediclinic hospital and be treated, or be provided with primary healthcare services, and for the NHI to pay for that. At present, if you want to go to Mediclinic, you must have medical aid, And as you have seen from the papers, medical schemes cover only about 16% of the population, but about 49% of our GDP goes to funding private healthcare, and 51% is shared by the 84% that remains. And NHI is to fundamentally restructure the funding system in order to enable access. So it is not just about improve the public hospitals and let those who can go to public hospitals continue going to public hospitals. It is funding so we can all access quality health care from the nearest provider in your community that you can register with. And so when, and I'm talking about costs, so when you're thinking about who is concerned about this costs and the consequence that when NHI is introduced, it will cut down the role of medical schemes, because once NHI covers a service, medical schemes can only cover the remainder of that. Who is concerned and who would raise this insufficiency of information? These are stakeholders who can engage experts, as BHF has done, and it is engaged Dr. Armstrong. But what Dr. Armstrong does undermines the argument that there was no sufficiency of information, because Dr. Armstrong takes the figures from the Green Paper, updates them. Those figures were, the estimations in the Green Paper were based on 2010 figures. So she says we are now much later. She updates those to 2023 figures, and then she comes up with a huge estimations of what it's going to cost. So what does that tell you? A stakeholder with the minimum information can do the exercise required to say, actually, it's not going to cost what you say it's going to cost. It's going to cost more, and this is our submission. Don't adopt this bill because it is not going to be feasible. That's exactly what they did in those stakeholder meetings. That's what the stakeholders were saying. That's the same case they're running in the High Court. They're saying this thing is not feasible because it'll cost much more than the department has said it will cost. So that's the first point. But it's important to also see what Dr. Armstrong acknowledges. And I refer the court to paragraphs, the court can look at this, 147 and 165. 147 is at 003-327, and 165 is at 003-334. You recall I said she doesn't reject the WHO advice, but she records at those two paragraphs that it is unhelpful, that projections of cost become unhelpful the more into the future you look. So it's fine if you're looking at a 2-year project, 4-year, 5-year project, but once you're talking about a 25-year project or 2 decades project, the projections are unhelpful. She acknowledges that. She says so as much. And if you want to have a look at where she then does the calculations of the shortfall, you will see at pages 003-333 at paragraph 164. And you will see from there that what Dr. Armstrong does is to calculate shortfalls from 2025-26, 26-27, 27-28, 28-29, 29-30. And she finds shortfalls all in those years, but we haven't even started doing anything to implement NHI. As they're all telling you that in the High Court there is an order saying there will be no implementation. But the reason she makes this mistake is that earlier in her report she says it's only, they're anecdotes. It's anecdotal that the NHI will take decades to implement. She says so. It's just anecdotal, but it's not anecdotal, it's wired into the legislation itself that it is going to take, it's going to be phased in implementation. So with respect on the minimum information, financial information, the stakeholders such as BHF who are the ones complaining in this court, you don't have Mam Kumalo from my village complaining, you have BHF. BHF had sufficient information. It could do the exercise that it hired Armstrong, Dr. Armstrong to do for purposes of this case, to do for its submissions. In fact, it made those submissions about this thing is not sustainable. Then there is the second point. The third point about financial implications is they say that that was not considered. Oh, well, I've indicated that both the green paper, the white paper, and the memorandum deal with financial implications. Those were before Parliament. They're all public documents which BHF considered. But in addition to that, after the summary that you see in AA7 of the debates that took place, you will see in the answering affidavit of Parliament at pages 004-127 that it's wrong. It's not true that Parliament did not consider these complaints. Parliament considered them, but Parliament disagreed with BHF that you need a feasibility study and instead agreed with the department. That's why they say the department was, Parliament was always willing to agree with the department, but it agreed with the department because the department produced support for its standpoint, which was the WHO report and expert advice that it refers to. But you will see at paragraphs 246 at 004-127 that Parliament explains that at various meetings it dealt with this issue and accepted the department's advice and quotes that advice at 246.1.2. And what is quoted there is from the transcript of the meeting of the 22nd of November 2022. The actual meeting report is AA15, which is at 004-963, and the court can also look at AA16 004-1043. But that's verbatim that they accepted the WHO advice. So if Parliament acted irrationally in accepting that advice and not conducting a feasibility study, you are in the realm of a rationality challenge and not a public participation challenge. So there was, and we have already made the point, and the Parliament also says that the department explained and Parliament accepted that the aim was NHI is not just to reconfigure the delivery of health services as between public and private, but it is to introduce efficiencies in the system. Firstly, the payment mechanisms for providers currently is fee for service. So you go, you have a finger, they deal with a finger, they charge you for that. You go for a hand tomorrow, they charge you for that, and so on and so on. And their technology improvements, the big machines that they buy, those machines require to be paid for. So there is always an incentive to over-service, and that drives the cost of healthcare and make healthcare delivery inefficient. What NHI seeks to do is not to transpose those inefficiencies into NHI, but is to transform the payment mechanisms to new payment mechanisms such as the capitation mechanisms for payment, and to control pricing as opposed to now where medical schemes price whatever they can negotiate with the private hospitals. They price whatever they can. So I was making the point that Parliament says that the department, and we accept that, they intend to keep spending within 8.5% of GDP, which is the current spending on healthcare, is 8.5% of GDP, but it is the distribution of that 8.5% of GDP which needs correction, because 49% of that goes to 16% of the people in the private sector, and the remaining 84% shares the remainder. And that requires change. Now, the other information that the BHF said it wanted.
That is more than rounding off, Mr. Manager. You may cover some of these aspects during questioning.
Yes.
Yeah.
I didn't hear the rounding up. I beg your pardon. I beg your pardon.
When the bell rings, you hastily round off.
Yes, yes. I'm almost rounded off on that financial information, yes.
We'll proceed after the lunch adjournment. We'll take a 40-minute adjournment and come back at 2:15.
As the court pleases.